Hi, I'm Josh Lawler. I am a partner at the law firm of Zuber, Lawler, and Duca, where I practice IP and securities law and head our new technology practice group. And today, we are going to talk about regulations that apply to ICOs and token issuers. Okay, let's get into this. But before we do, this is not legal advice. This is not investment advice. Very important everybody remembers that. If you're going to get into this area, get competent counsel. I was at a conference last week where a Department of Justice official said, and I quote, "If you're a hammer, everything is a nail." We already know about the Securities and Exchange Commission. We already know about the 33 Act, no unregistered public offerings of securities. That's where our 506C private placement comes in, or our Reg A+, which is an exempted offering. Fine. Should be obvious, but don't commit securities fraud. Material misstatements or omissions in your disclosure materials are bad, so don't do that. Insider trading, don't do it. And of course, when these tokens are securities, and ultimately I think they will be and should be, you have to do Exchange Act reporting, and you have to have restrictions on affiliates. Then you've got FinCEN, Financial Crime Enforcement Network. And FinCEN requires that if you are going to be a money service business, and a money service business, which has a very long definition for our purposes, comes down to somebody who is basically issuing or exchanging virtual currencies that are convertible to fiat. So there's a very important distinction here, which is that if you've got a SAFT, a forward contract for tokens, that's not yet a token that's convertible to fiat, and arguably may not be subject to the same registration requirements. And that all seems kind of painful, but as we go through the rest of this, you're going to see that actually having your token as a security may in fact be the easiest way to go. And of course, you've got the IRS, and the IRS is going to get into you as an issuer and an ICO, and the fact is that it can get very confusing, and structure really counts here. Let's say that your token is considered equity. And we can do this by setting it up, basically as a share of some type of stock called a token, no voting rights, low economic rights, fine. And it's a C Corp. You're probably not going to have income tax on the sale of those tokens. If your token is a, quote, utility token, and I do hate the term, but if it's a utility token, that's basically selling a good or service, federal income tax, state income tax. You may be able to defer it a little bit through revenue recognition rules, and of course, you may be able to deduct your expenses against it, but you're dealing with income tax. If the tokens are considered property, if you're doing something where your token represents a piece of real estate, then you're in a different taxable area, and your tax may be based on the price you sell that token for, minus how much it costs you to put those assets behind that token. Finally, on the tax front, airdrops. We like airdrops. Airdrops are a way that you might be able to get your tokens out to the world without violating securities laws, but the IRS, of course, sneaks in and makes things difficult. It's possible that the value of the token that you give away is going to be taxable to the recipient. The IRS, of course, requires when you pay somebody money that you report that you've paid the money, and sometimes that you withhold some of that money. And if you're airdropping tokens and they have value, there's a chance that they're going to go and ask for reporting. Well, let's talk about the FTC, Federal Trade Commission. About a month ago, the Federal Trade Commission got an injunction in the Southern District of Florida federal court against a few individuals that were running a crypto hedge fund. Now, in this case, the fund was completely fraudulent. It was a Ponzi scheme. It deserved to be shut down, but the point that you should be focusing on is that the FTC, which protects consumers' purchases of goods and services, it's not in securities, it's not in money laundering, they've decided they're involved. So again, you have to be very careful about how you market your tokens. The states all have their own securities laws. If you are issuing tokens, having them be securities and being able to issue them via methodology that gives you state law preemption is actually really nice and a really good idea. Some of the state securities laws define a security even more broadly than the federal securities laws. You're used to the Howey test. Well, some of the states have something called the risk capital test, which basically means that if you invest in something or buy something that is going to go up in value or going to go down in value based on what other people do, even if it's something that's utility oriented, they're still going to treat that as a security. The states also have some other issues. They, in some cases, need you as an issuer or a principal of an issuer who's selling your securities directly to actually register as if you were a broker-dealer. The states also have their own money transmitter laws, which apply to issuers and exchangers of virtual currency. And unfortunately, they all require separate license applications. So it can be very expensive and very time-consuming. And quite honestly, there's no good reason for it, but unfortunately, that's what we have at the moment. Certain states are harder than others. New York, of course, enacted the New York BIT license requirement. Massachusetts has taken some actions, Texas as well. So you have to look at all of these things. In some states, you might just not want to sell your token into. And then, of course, the states also have sales tax, depending on whether your token is a good or service or whether it's property. If you're in a state that has sales tax, you've got to deal with sales tax. And then there's the Department of Justice. The Department of Justice has kind of an oversight for enforcement. Before we get into specific examples, I'm going to add right here the Foreign Corrupt Practices Act, FCPA. The FCPA basically means don't bribe people. Don't bribe government officials, certainly. Don't bribe certain people in larger organizations that may be state-run. Don't bribe people. Now, why would you? The idea, of course, is you get something of value for your business. And in the case of a token issuer, typically it's going to be something that assists with adoption of the token and growing the token economy. Okay, well, sounds easy enough. I'm not bribing anybody. Well, almost all of the ICOs I've seen have retained some tokens for the purpose of fostering the growth of the token economy. And depending on who those tokens go to, particularly if they go to those persons for less value than they may actually be worth, that's potentially a Foreign Corrupt Practices Act violation, and that is a big deal. There's no question, and the Department of Justice can pursue people who violate that law. What has the Department of Justice been up to lately? Within the last month, the DOJ indicted and arrested a couple of Canadian nationals who were using US bank accounts for money laundering. These Canadian nationals were operating 3 different companies. One was called Payza.com. That was the center of this particular indictment, and there were a couple of exchanges also, just trading Ripple and Ether and Dash. I should add that they're probably making the right move here. They're going after fraudsters, but it's the way that they're doing it that really warrants attention. The Department of Justice went after them because they had not registered as a money services business or with any of the states as money transmitter. And these guys could face up to 25 years in jail on those charges. Interesting that that's what they used to go after them. They could have probably gone after them for federal wire fraud also because they were breaking both Canadian and US tax laws. The Department of Justice, in doing their public announcement on this arrest, stated more or less that they were demonstrating that the Department of Justice has the desire to vigorously enforce laws that were meant to protect the American consumer. Certainly a noble purpose, but unfortunately, if you're a hammer, everything looks like a nail. Moral of the story here, get good counsel, listen to your counsel. That's it. I hope this was helpful. I am Josh Lawler. You can reach me at jlawler, the letter J, Lawler, at zuberlaw.com. Comments are always welcome.